This is a demonstration on identification evidence in Victoria in 2013. To get started, let's have a look at the dictionary definitions from the Evidence Act of identification evidence. So, first of all, there's the main definition, which is identification evidence: an assertion by a witness that the defendant was or resembles a person who was present at or near the crime at or about the time that the crime was committed, and that assertion is based on what the witness saw, heard, or perceived. So pretty much what you would want from a witness who's identifying the defendant, that is the accused, who was there, saw the accused in the act, etc. Then there's recognition evidence, where the defendant is purportedly identified by a person who knows or is familiar with him or her. Very similar to identification evidence, it extends to identification evidence, so it's for all intents and purposes the same thing as was noted in Trudgett against the Queen in 2008 in New South Wales. However, resemblance evidence is a lot weaker. That's where the defendant resembles, visually, orally, or otherwise, a person who was present or near where the offence was committed. The consequence is that the weight to be given to this kind of evidence is a matter for the jury, and resemblance evidence on its own is insufficient for conviction. It ordinarily forms part of a circumstantial case, such as Pitkin against the Queen in 1995 or the Queen against Cohen in 2002 in New South Wales. And before we proceed, let's bear in mind a quote from Lord Devlin that really sets the tone for pretty much everything to do with identification evidence, which is that the highly respectable, absolutely sincere, perfectly coherent, and apparently convincing witness may, as experience has quite often shown, be mistaken. So with that in mind, let's move on. So the main question when we're looking at identification evidence is whether the identification of the accused by the witness was admissible or is admissible at trial. If it is, there are other questions to ask, and if it's not admissible, then the identification evidence is not admitted. It's pretty simple. So how do we determine whether identification evidence is going to be admissible at trial? The first question, the key question to ask before anything else, is whether the witness was intentionally influenced by the police to identify the accused. This is a showstopper. If it transpires that the witness was intentionally influenced by the police to identify the accused, then the identification evidence is inadmissible. Full stop. But in most cases we'll look at that's not going to be the case. So we then move on to acceptable forms of identification evidence. And the main one is visual identification, but there's also picture identification, which is different from visual, where you're actually looking at the person rather than a picture of the person. There is also facial mapping, body mapping, and voice recognition. So under visual identification, the main method is an identification parade, but there are also options if an identification parade is not possible for visual identification of the accused in isolation or in court, which is the weakest of the three. With picture identification, we have photo boards, photo fit, or a police sketch. Facial mapping, because it's very, very new, is not proof of identity, although it can be used as proof of non-identity, and it's really used more to provide evidence of similarities rather than identification. And body mapping is considered or at least is has the potential to be more powerful evidence, more compelling evidence, but again is very, very limited and is really only of note in the case of Murdoch against the Queen. If we are talking about voice identification, there are really two ways of going about it. One is with witness recognition, so either hearing the accused speak or hearing a recording of the accused speak, and there is also the possibility in some cases of using audio voice recognition software to make a match between two separate recordings of the voice of the accused. So let's go into that a little bit more and see if there's anything else that we need to point out. So if we're talking about identification of the accused in the most compelling, most useful way, we're talking about an identification parade. And the first question is really whether the police did make use of an identification parade, and if they didn't, why they didn't, because if they do not have a good justification for not availing themselves of an identification parade, then the other forms of visual identification evidence may not be admitted. So we can so the first question to ask is whether there was an identification parade with the accused's consent. So the accused does not have to consent to participating in an identification parade, and if the accused does not consent, then they can't go ahead with it. So if there are any of the following four scenarios, then the police are relieved of their obligation to hold an identification parade. If the accused outright refused to participate in it, if the accused refused to participate unless his lawyer was present and there were reasonable grounds to believe that it was not practicable for that lawyer or person to be present, if the police determined that it would be unfair to the accused to hold an identification parade, or if it would not otherwise be reasonable to hold an identification parade, then in each of those instances an identification parade would not be required. But assuming that it's none of these four scenarios, it's probably going to be the case that an identification parade was held with the accused's consent, and for our purposes we're going to assume that the accused was identified by the witness. And although in the Victorian legislation there is no outline of the procedure, it is governed in Victoria by the Victoria Police Manual Operations, section 111, subsection 1, titled Identification of Suspects and Offenders. And if the court, or if the police are referring to the Commonwealth Crimes Act, then the procedure for identification parade, which is very similar to the procedure set out by the Victorian Police, is set out in section 3ZM to ZQ. So if the accused does not consent to an identification parade, the prosecution cannot adduce this fact as indicating guilt, but it can adduce this fact to justify an alternative method of visual identification. Refer to the case of the Queen against Davies in 2005 in Victoria. So visual identification in isolation could be in a custody yard or in the foyer of a court, and if we're talking about identification in court, which again is very weak, it's very unreliable. It could be at the magistrates, or it could be in the dock. But that's given the least weight possible. If we're not talking about visual identification, the next one up would be picture identification. So that's identifying the accused from a police sketch, photo fit, or photo board. And this and all the others that I'm going to go through are only acceptable if an identification parade was justifiably not held. Another form is facial mapping, and it's only really of use if there are multiple points of match between the face of the accused and the face available on the computer. And as I said before, it can only be used to provide evidence of similarities and differences, and it cannot be taken as direct identity proof, but it can be used as proof of non-identity. Body mapping is similarly hazy, and voice identification, there isn't really anything to add to that. So that's pretty much an overview of the acceptable forms of identification evidence. So, assuming that we do have an acceptable form of identification evidence, another question to ask is, as per the Evidence Act, Section 79, whether there is relevant opinion evidence as to the unreliability of the witness's identification evidence. So there were some cases where experts were called in who testified as to the unreliability of the witness's identification evidence, but generally speaking it hasn't gone very far, and I haven't added the cases at the moment, but I'll add them later. So let's say that we do have a match. Let's say that there is identification evidence by the defendant of the accused by the witness, which was admitted to trial, which was admissible. Okay, so let's close that. So the next question is whether there is judicial discretion to exclude the evidence. And there is, but did the judge exercise this discretion to exclude the evidence? And the consideration is ultimately whether there is a danger of there being an unfair prejudicial effect of the identification evidence exceeding its probative value. So every time identification evidence is admitted, there's always the probative value, its value as evidence of moving the process along, but there's also the danger, there's always the risk that simply in the act of identifying the accused, there could be a certain prejudicial effect, and in some cases the prejudicial effect is considerable. So there are a few considerations, a few things to take into account when considering the balance between these two. So first is the possibility of prejudice arising from the mode of identification used, which might lead to an inference that the accused was known to the police and had a criminal record. The danger of overestimation by jury of the probative value of identification evidence. The danger of the accused not being able to test the reliability of the identification evidence. The danger of unfair emphasis on that evidence. The likely effect of any judicial warnings, that is, that the judge may give a warning that the jury should take into account certain weaknesses apparent in the identification evidence, but the jury might ignore those warnings, and also the existence of other evidence tending to adduce the importance of eyewitness evidence. And this principle is expressed in the case of Quoro against the Queen, 2008 New South Wales, where Justice Johnson said at 64 there must be a real risk that the evidence will be misused by the jury in some way, and that the risk will exist notwithstanding the proper directions which it should be assumed the court will give. It's worth bearing in mind that trial judges are generally very reluctant to exclude eyewitness identification evidence, however unreliable or weak it may seem, and there's generally speaking a strong preference for warnings and directions to the jury rather than leaving that evidence out. Now, let's just follow through with this notion of judicial discretion to exclude evidence. If we are going to consider, if we are looking at eyewitness evidence or any other kind of identification evidence that might seem to trigger sections 135 and 137, we're looking, the first question to ask is whether there is an objection to the evidence by either party at the trial. And if there is an objection, the court must exclude the evidence, as we saw in the case of the Queen against Nguyen in 2003 in New South Wales, where it was held that the identification evidence was of extremely low probative value and there was a danger of unfair prejudice, and the danger of unfair prejudice was substantial, so the evidence was excluded. But if there's no objection to the evidence at trial, the next question is whether the accused was legally represented. And if the accused was legally represented and there was no objection to the evidence at trial, and then it is held that section 137 does not impose an obligation to exclude identification evidence. And that was expressed in the case of FTP against the Queen in 2008 in New South Wales. So if the judicial discretion to exclude evidence was not exercised, then there are basically two judicial directions that are stipulated by statute. One is in section 116 of the Evidence Act, which is usually mandatory but not required if the reliability of the identification evidence is not disputed. And then there's a second judicial direction which can be triggered by request of either party, and that's in section 165, where the judge is required to give a warning as to the unreliability of the evidence. So let's look at that in a little more depth. So the warning, the judicial direction, the specific warning that must be given as per section 116 is that there's a special need for caution with respect to the identification evidence, and also this direction must include general warning about the unreliability of evidence. So if the reliability of the identification evidence is disputed, then the warning is definitely required, as was expressed in Darnoa against the Queen 2003. And so if the reliability of the witness's identification evidence is disputed, then that triggers the section 165 subsection 2, that the judge must warn the jury that the evidence may be unreliable and inform the jury of matters that may cause it to be unreliable, and warn the jury of the need for caution in determining whether to accept the evidence and the weight to be given to it. Now, neither Section 116 nor Section 165 requires specific words to be used, but it must be cogent and clear. So on what grounds might the reliability of the witness's identification evidence be disputed? There's the insignificance of events observed, there's the length of period of observation, whether the witness just got a quick glance, whether the observation was under stress. For example, there are studies to indicate that if you're under a great deal of stress, your recollection might not be very clear. However, archival evidence suggests very strongly that the people who are under enormous pressure do recall things very clearly, all things being equal. Another consideration might be the observer's physical condition or the observer's perceptual set or expectancy, so whether there are stereotypes at play. Retrieval from long-term memory is an active process. There's always the risk that the witness might fill in some information. The lineup might have been constructed in a way that's unfair, and so forth and so forth. So those are some ideas, those are some things to bear in mind when considering whether the reliability of the identification evidence is being disputed. So let's say it is disputed. Well, then the trial judge has to give a judicial direction, and the judicial direction, the trial judge has to isolate and identify for the benefit of the jury any matter of significance which may reasonably be regarded as undermining the reliability of the identification evidence. And if it goes to appeal and it is held that the instructions given to the jury were not sufficient, if they were not adequate, then the case will be overturned, as in Domican against the Queen. So if it's adequate, well good. If it's not adequate, it can go on appeal. If there are multiple witnesses, if the accused has been identified by a number of different witnesses, then the jury has to be warned in clear terms that even a number of honest witnesses may have been mistaken, referred to the cases of the Queen against Sweden 1980 and the Queen against Haley in 1984. But as long as the jury has been given this clear warning, they may consider the cumulative effect of multiple witnesses positively identifying the accused. So obviously if a few people identify the accused, it's more persuasive than just one person identifying the accused. We just have to bear in mind, we just have to remember that in just about any case there will be either, as per Section 116 or Section 165 of the Evidence Act, a need for judicial direction, and even if there isn't, there's a very strong common law tradition of doing so anyway. So that's judicial direction, and that's pretty much all there is to identification evidence. So I hope this presentation has helped you, the viewer, understand this topic a bit better. The maps are available to those that I'm sharing maps with, and will eventually find the way to my blog, which is tabulalex.blogspot.com. All the details will be below in the About section of the video. So thanks very much for watching, and I hope this has helped.